Hello friends, this is Sandeep Singh IRS. Today I'm going to discuss about something which forms the crux of legal system in India. Not only in India but outside also. So based on my experience of working with the departments like Customs, Enforcement Directorate and GST, I've come up with this video to help the genuine taxpayers to deal with the notices issued by the tax departments. If you like this video, then please hit the like button, comment and subscribe to the channel. If you have any questions or queries, please ask me in the comment box and I shall definitely help you out with my views on your queries. So today we are going to talk about a very important pillar of the principles of natural justice, especially in taxation and more particularly in GST. So please watch the video till the very end. So now let us begin. What exactly we are going to talk about it. So today we are going to discuss some important updates from the Ministry of Finance, specifically from the CBIC, that is Central Board of Indirect Taxes and Customs. So if you are involved in GST, customs or central excise matters, this information could be vital for you. So CBIC has issued an instruction dated 5th of November 2024, that is yesterday. So let us see what are the contents of the instructions issued by the CBIC yesterday. So on the 5th of November 2024, the CBIC issued a fresh instruction regarding the conduct of personal hearing for cases under the CGST Act, IGST Act, Customs Act, Central Excise Act and the Finance Act. So now let us break down the key points which you need to know to understand the contents of these instructions. So first, now let us have a look at the background. What exactly is the background? If we understand the background, then we can understand this notification, this circular or this instruction better. The CBIC had initially issued an instruction on August 21st, 2020, mandating that all the personal hearings by adjudicating or appellate authorities be conducted in a virtual mode, specifically through video conferencing. Now, this was especially useful during the COVID pandemic as it allowed hearings to continue without physical presence. So there was an amendment brought about by CBIC only in 2022. So basically in July 28, 2022, an amendment was issued. According to this amendment, virtual hearings would only be held at the request of the taxpayer. If the taxpayer preferred an in-person meeting, the authorities were required to conduct the hearing physically. But now things have changed again. So we have got a revised instruction issued by CBIC yesterday, that is 5th of November 2024. So now let us see what are the contents of this particular instruction. So after receiving multiple representations and requests, the CBIC has re-evaluated the situation. In the latest instruction dated 5th of November, they have decided to revert to the original guidelines from 2020, the first guideline, 2020, August 2020. So what does this mean? This means that from now on, it is mandatory, I repeat, it is mandatory for all the quasi-judicial and appellate hearings under the specified acts to be conducted in virtual mode through video conferencing. It is mandatory. So now you may ask, whether there may be any exceptions for this personal hearing. So some of you may wonder if there is still an option for physical hearing. Yes, I think in my personal view, yes, there is. Though it is mandatory, but if the taxpayer specifically requests an in-person hearing, the authorities may allow it. However, they must document the reasons for choosing the physical mode. So while virtual hearings are the default, there is a possibility for an in-person session if needed at the request of the taxpayers. So to sum up, all the personal hearings will primarily be conducted online unless a specific request for physical mode is made by the taxpayer and approved by the department. So now let us see why personal hearing is so important for the taxpayers. What's the big deal? Why it is so important? Personal hearing in GST is very crucial for ensuring fairness and adherence to the principles of natural justice. Under Section 75(4) of the CGST Act, a personal hearing must be granted if requested or when an adverse decision is anticipated against the taxpayer. This was affirmed in cases like BL Paharia Medical Stores versus State of UP, where the court emphasized that the adjudicating authority must provide a personal hearing before imposing penalties. Similarly, the Gabriel India Limited case reinforced that personal hearing are mandatory even if not explicitly requested by the taxpayer. So such provisions protect taxpayers' rights and ensure transparent decision-making processes. So violating the principles of natural justice by tax authorities can lead to several legal repercussions. So the taxpayer must know their rights. So what are the repercussions? Number one, quashing of orders. Courts may annul decisions made without following the principles of natural justice, as seen in cases like Hydro Pneumatic Accessories India Private Limited versus Assistant Commissioner of State Tax, where the Bombay High Court highlighted the necessity of personal hearing under Section 75(4) of the CGST Act. Number two, remand for reassessment. Courts may require cases to be reassessed, ensuring compliance with natural justice, which was emphasized in Rajesh Kumar versus Deputy CIT, where the Supreme Court mandated adherence to these principles even in the absence of explicit statutory provisions. Number three, judicial scrutiny. Persistent disregard for natural justice can attract judicial scrutiny and potential disciplinary action against tax authorities, undermining their authority and credibility in administrative proceedings. So these repercussions underscore the necessity for tax authorities to uphold procedural fairness to maintain the integrity of tax administration. So various high courts have supported SSCs on this matter, mandating that the personal hearing is a must. It is a basic tenet of the principles of natural justice. So now let us see some of the cases, important cases, which has mandated the personal hearing. One is the Devlok distributors. It was in 2024. This case was in 2024. The assessees or petitioner challenged the tax determination under Section 73(9) of CGST SGST Act, issued without personal hearing. High Court set aside order and remanded the case to appropriate authority to issue fresh order after granting the assessee or the petitioner opportunities for personal hearing. So there are so many cases wherein the personal hearing has to be held to be important, like Everyday Industries. It was again a case in 2024. So all these cases have very categorically stated that personal hearing is a must. So as a taxpayer, you must keep in mind that whenever you get a notice, you must ask for a grant of personal hearing. If you're comfortable, virtual mode. If not, then you can also request for a in-person hearing. So if you like the video, please hit the like button and comments. If you have any queries, you can ask me. So till then, see you in the next video. Take care.